For those of you who haven't met me, my name is Tom Miles. I'm the Dean of the University of Chicago Law School. And on behalf of the University and the Law School, it's a pleasure to welcome you to this conference on gun violence. It is a pleasure to have so many members of our community from across the university and so many community partners and people from outside the university join us for this important discussion today. Now, the University of Chicago was founded with a particular purpose in mind, and that is academic excellence and superb research. The purpose was to add to knowledge and to have knowledge that has impact on the world. And since its founding, the university has pursued this, and as a result, we have studied the most important social questions, thought deeply about them, deeply and ambitiously, and often changed paradigms and changed whole ways of thinking about the most important social topics of our time. And we also do that through challenging and empowering education, certainly in the law school and all across the university. And the University of Chicago Law School in particular, as a professional school within a research university, we have since our founding taken an interdisciplinary approach to our teaching and to our research. As a result, we regularly reach out and engage with colleagues from across the Midway, as we say here, across the Midway, other units of the university, to apply their ideas, their thinking, their knowledge, and their methodologies to find important answers to challenging social questions. And so very much in that spirit, today we gather with an incredible group of scholars, faculty experts, university leaders, and community partners from a range of different fields and perspectives to examine the pressing question of gun violence. Now, understanding the questions, understanding the factors that contribute to gun violence and the impact on the communities and our country requires this comprehensive and multifaceted approach. And so as you look over the program today, you will see each one of the panels tackle a different part of these questions, come at it from different methodologies and different perspectives. So we'll start this morning with a panel on the legal landscape, which will help us understand how the law shapes the opportunities for managing gun violence. We'll then explore opportunities and challenges presented by the political and policy debates around gun control and gun violence. We have then an incredible group of colleagues from our medical center and medical experts from across the country to look at public health initiatives and to understand the medical impact of gun violence. And then this afternoon, we've got several leaders from the School of Social Service Administration, the Urban Education Initiative, and the University of Chicago Crime Lab that will focus on bridging the gap between research and policy through their work locally in Chicago schools, with the Chicago Police, and through youth outreach groups. And then we'll close with an important set of perspectives on the business community and philanthropic organizations and how those entities, those platforms, can also drive efforts at understanding and efforts at programming at local and national levels. And I hope that today's discussion with these experts from policy, from law, from medicine, from education, from the business community and the philanthropic community will lead to more discussion and more collaboration to help us understand and advance our progress on this important question. Now, I thank all of you for participating today. I thank all of you for your engagement. Every one of our panels, we expect to have an opportunity to have questions. I owe a great debt of gratitude to all of our speakers from across the university. As you look at this program, you see some of the greatest talent in the country on these questions. We're so grateful for their time, for their coming, and sharing their expertise and their perspectives with us. I also want to thank the University of Chicago's communications team, our events team, for making this event possible. And in particular, I want to single out one person whose vision created this event, and that is Tom Cole. Tom Cole is a graduate of law school, class of 1975. He has had an extraordinary career as an attorney at the firm of Sidley and Austin, and for more than a decade, he led that firm as its chairman. He is an expert on corporate governance. In fact, he has taught corporate governance at this law school for a number of years and has recently published a book on CEO leadership. Tom has given great service to our university in many forms, most especially as a member of the Board of Trustees. And he has also given great service of his time across a range of civic organizations. So we're so grateful for Tom for his vision in this. And I will add, this is not the first time Tom has done this. A few years ago, he gathered leaders from across the university to look at important questions in healthcare and the Affordable Care Act. And so I'm so grateful to him for his leadership and convening power in bringing together the expertise on these important social questions from all across the university. So without further delay, again, I will say welcome, and let's watch our first panel. So let me invite up the members of our first panel to come and join us here, and we'll start our conversation. So thank you, Daryl, John, and Bill for being here. We're very excited to start. Of course, as a dean of a law school, I'm a little bit biased. I thought, we've got to talk about the law as the first panel. So thank you for being here. I think what we'll hope to accomplish in this panel is to cover a number of topics. As all of you know, the legal topics in the area of gun violence are complicated, and we could spend almost the entire day, I'm sure, on this topic of just the legal dimension. But what we'll try to do is highlight a few topics. One is we'll start by talking about the history of the Second Amendment and some important recent decisions in that area. And then let's sort of look forward to the future of the legal landscape and what sorts of challenges under Second Amendment law might arise. And then if we have an opportunity then also to talk about state and federal firearms regulation. That's an important, that state dimension often doesn't receive quite the attention perhaps it should. And then also address some other areas of law, including consumer protections, insurance regulation, and the criminal law, of course, and how that affects our understanding of gun violence. So let me give very brief introductions. Daryl Miller is the leading Second Amendment scholar in the country. He is professor of law at Duke University Law School, and he is also co-director of the Duke Center on Firearms Law. John Rappaport is currently assistant professor of law, soon to be professor of law, and is also the Ludwig and Hilda Wolf Research Scholar here at the law school. His scholarship focuses on criminal law and criminal justice, and in particular focuses on private and public forces and how those interact in shaping criminal justice. And then Bill Taylor is Deputy Director for the Second Amendment litigation at Everytown for gun safety. So thank you, Daryl, Bill, and John, for joining us.
Thanks.
So let's start by talking about the Second Amendment. And I think one very important Supreme Court decision that has come down in recent years is DC versus Heller. And so I think it makes sense for us to start there. And now, in particular, we could spend, as I say, I think we could spend the whole day just trying to parse and understand the Heller decision. It's thorny, it's complex. In this one in particular, could you just briefly walk us through sort of the legal landscape on the Second Amendment, and including Heller and what it means, and any other important cases that you see having recently arisen since Heller? Daryl, do you want to start?
Sure, absolutely. And thank you so much for the invitation to be here. I'm really excited to be on this panel and talk about this. I'm glad you actually framed the issue about, starting first with the law, because not just to sort of trumpet our own horns as sort of lawyers, but the legal landscape is what provides opportunities for the other important kind of work in the medical or the criminological field in terms of coming up with policy solutions for gun violence, but they can only happen within a legal framework where we understand where the boundaries are. And one of the boundaries is this Second Amendment case called District of Columbia versus Heller, which you've identified. So prior to 2008, for over 200 years, there was a Second Amendment, but no one had understood as a legal matter, at least no judge had enforced it as a legal matter, to say that you had a right to keep and bear arms for purposes that had anything to do other than with a well-regulated militia. That all changed in 2008 in this case called Heller. In fact, the notion that there was an individual right seemed so far afield that Chief Justice Warren Burger, who was retired, had called it a fraud, an actual fraud perpetrated by the National Rifle Association. And what happened between his statement then and 2008 was a very deliberate and successful campaign among activists to turn their vision of what the Second Amendment was into positive law, into a court opinion. So District of Columbia versus Heller had to do with a regulation in D.C. that was passed in the wake of a spike in gun violence in the late 70s that basically made it almost impossible, except for certain grandfathering provisions, to have an operable firearm in the home to protect yourself. Dick Heller was a special officer of the Federal Judicial Center. He was also an activist, and he ended up suing D.C., claiming that this violated his Second Amendment rights. And in this opinion, the court held for the first time that, in fact, the Second Amendment guarantees an individual right to have an operable firearm in the home for private purposes such as self-protection. And after the Heller decision, there was a follow-on case from right here in Chicago called McDonald versus City of Chicago, which incorporated that same principle about a individual right to keep and bear arms to state and local regulation. Chicago had a similar gun violence problem, had addressed it similarly with a regulation, and it was struck down as violating the Second Amendment as applied to the states. And that's really where a lot of the action in terms of litigation happens now, because the vast regulatory landscape in terms of guns is not typically at the federal level. There are some federal regulations, important ones like the 1934 Firearms Act or the 1968 Safe Streets Act. But the vast majority of regulations happen at the state and local level. So the regulatory environment that we're in tends to be dominated by those kinds of jurisdictions. So what did Heller say beyond that a person has a right to an operable firearm in the home for purposes of self-defense? Well, it didn't say much. It's got some very odd language in it about the kinds of firearms that are permitted are firearms in common use. It didn't define what common use meant. It didn't actually even define to what extent firearms can be taken out of the home. As, for example, when somebody wants to carry a pistol with them in their car or on the streets with a license or without a license. And so in the post-Heller, post-McDonald world, a lot of the open questions are currently being litigated on those dimensions. That is, what kind of weapons are protected by the Second Amendment under this common use test? Where can you carry weapons and have weapons other than in your home? Can you carry them outside? Can you carry them in your car? The Heller decision was very, very express about saying that it was not destroying all regulation. In fact, it said that long-standing prohibitions such as guns in sensitive places like government buildings or schools, guns out of the hands of felons and the mentally ill, and certain types of commercial regulations of guns were presumptively constitutional. But what overcomes that presumption is up for debate and the stuff of litigation today. So what kind of regulations on gun sales and guns transfers, that's also at issue, as well as where you can carry them and what actually counts as a gun or an arm. And who can possess it. And this is the nature of the litigation that's been going on in lower courts, where for the most part, the lower courts have been upholding gun regulations with a few cases, including one here in Chicago about public carry of firearms being held, a prohibition on public carry being ruled unconstitutional. But for the most part, the regulatory environment has been upheld, but that might change. The Supreme Court has not heard a case in 10 years. It granted cert on a case just this past term but it might not actually decide it on the merits because the law was repealed. So that's the kind of architecture of where we are. I don't know if Bill wants to add anything.
Thank you, Daryl, and thank you, Tom, and everyone for having me here. I would just add to that, as you mentioned, Heller itself was a very limited decision. The law at issue in Heller was DC's total ban on possession of handguns in the home and an requirement that firearms be kept inoperable at all times, even if you were using them and needed them for self-defense. So it was an outlier extreme law, and the court itself, that was the law that struck down. The court itself made clear in its opinion that the Second Amendment right, it said, is not unlimited. It's not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. And then it had a list of, what is presumptively lawful regulations. And these, talked about prohibitions on concealed carry were okay. Longstanding prohibitions on possession of firearms by felons and the mentally ill. Laws forbidding the carrying of firearms in sensitive places like schools and government buildings. Conditions and qualifications on the commercial sale of arms, and it said, well, this is not exhaustive, these are just examples. And we've learned since, which might be, for us to keep in mind what's going to happen with the court next, we've learned since from Justice Stevens that that list and those exceptions were put in, it seems, for Justice Kennedy. That was what he needed for his fifth vote. So it's unclear where obviously with Justice Kavanaugh on the court now and a new, conservative 5 justices, what those exceptions will mean coming forward in the future. But that's what the limited, sort of a very limited decision in Heller, and the court really hasn't said anything other than McDonald saying it applies to the states. They had a case, Caetano v. Massachusetts, which was not even an oral argument, it was just a grant, vacate, and remand, but all they did there was sort of it was a stun gun case. Massachusetts had a total ban on carrying of stun guns. A woman who was having a stun gun because she was being threatened by her boyfriend was arrested for carrying a stun gun. She's a very sympathetic plaintiff. Went up to the Supreme Court. They said, well, the Massachusetts Supreme Judicial Court, the highest court in Massachusetts, just got Heller wrong. It said the stun gun ban was okay, and the stun gun wasn't protected because they didn't have stun guns at the time of the Second Amendment was enacted, and because stun guns, aren't used in the military. And that's basically everyone on the court agrees, and everyone who's read Heller agrees. Heller said that's not the analysis. You can't just look at weapons back at the founding. That's not how we're going to do this. But that's all, at least the per curiam opinion did. Justice Alito, joined by Justice Thomas, had a more, complete discussion perhaps of what his views were, but that's not the court's view. So that's what we know from the Supreme Court right now, which is not that much.
Well, thank you. And can I ask, just to press a little bit on understanding the implications of Heller. So Heller established an individual right, but at the same time, you both emphasized how it's limited in certain regards. And could you help us understand sort of what post-Heller are the issues that are being litigated in lower courts to help us understand how does the individual right balance with the limits on the individual right? What are the percolating issues in the lower courts in the wake of this?
Right. So I think like I had mentioned before, there's lots of sort of open questions about what kind of weapons are protected by the Second Amendment, who can bear them, where they can be born, and other kinds of related incidental, things having to do with firearms, like, can you microstamp ammunition or other issues like that. Now, again, the court has been pretty silent for a long time. It granted certiorari on this particular outlier case in New York City. It's certiorari is, for the non-lawyers in the audience, is when the Supreme Court decides to take up a case from a lower court and decide it. And New York City had an unusual regulation that didn't permit you to carry a gun from your home to a second home outside New York City or to a firing range outside of New York City. And that's been challenged by somebody that wants to take a gun to a second home or to a firing range outside the city. And the potential implications of that case is to try to clarify what exactly are the limits. Is the right really just about self-defense in the home with a firearm, or is there some kind of right that extends beyond the scope of the home? That's one of the salient issues right now in the United States, and the court hasn't directly addressed it. Now, in some ways, in terms of the sort of lower courts and the percolation on these issues, I think it's fair to say that the Supreme Court, Bill might agree with me, probably has more of an appetite now than it has for the past 10 years on clarifying these issues. So this case that I had just described, the New York State Rifle and Pistol Association versus New York City, that regulation was repealed, and so now there's not really something for the court to write an opinion on. It's what's known as moot. But there are a series of other cases that are lined up that the Supreme Court could take up if it ends up denying a merits decision on the NYSERPA case. Cases having to do with things like bans on assault rifles, asking, is this in fact an arm that's protected by the Second Amendment? Issues like, do extended magazines qualify as arms that are protected? What kind of regulations are permitted there? And probably, again, the sort of most salient issue is about the transport or carry of firearms. Now, it's important to understand that the regulatory environment for guns is not just about the Second Amendment and the Second Amendment rights, because many states will put rights on top of a floor that is set by the Second Amendment. So the Second Amendment says, for example, that banning concealed arms is permissible because that is an unusual, a dangerous and unusual method of having arms. That's what Heller itself says. But rights are a floor, and so states, through regulation, can put all kinds of rights on top of that. So many states have rules about saying that even though it's not constitutionally required to allow people to conceal carry, they will create regulations that say that you can.
Sure, thanks.
Even though you have some states, and these regulations on public carry vary widely. Some states require training for carrying firearms. Some states require no training at all. Some states require what's known as a shall issue regime, so you just have to show that you're not a felon and you're not prohibited because of some other qualification. You're of age. You haven't been discharged from the military dishonorably, for example, and then they just issue a license to carry a gun. Some states have what's known as a may issue. It's a minority of states, but some states have what's known as a may issue regime, which says that you have to show that you have some peculiar need to be able to carry a gun in public. For example, you for your job, you transport a lot of money, for example, or you're in particular danger because you have a credible threat against your life that's different from just a general background concern of safety. And these are the kinds of regulations that are going to be adjudicated, I would predict, in the next 5 to 10 years about what limits are constitutional on carrying firearms, what kind of limits on the actual arms are permissible, what counts as an arm, and that's what we'll see in the next 5 to 10 years, I guess.
Yeah, I agree with all of that. The only thing I would add is it's a little bit of a lawyer question, a lawyer issue, so I don't know how much I want to get into it, but probably the most important thing the Supreme Court is going to decide going forward is what the test is, how they're going to decide Second Amendment cases. So as we said from Heller, we know now the Supreme Court has told us there's an individual right unconnected to the militia for self-defense, at least to have a handgun in the home. That's the minimum we know. What does that mean for other sorts of, laws and regulations like public carry, like assault weapons and large capacity magazines, like minimum age laws? And how will the court go about assessing those laws? The lower courts have all that have looked at it in the courts of appeals agreed on what they call a two-step framework, where they first look to whether this is within the scope of the Second Amendment right, and for that, they look at history, text history, tradition, and then if they find it's, within the scope, and this is something that the Second Amendment covers, then they go and do a sort of traditional means and scrutiny analysis, which to lawyers, constitutional scholars, is things like, rational basis, intermediate scrutiny, strict scrutiny. And courts are basically, centered around intermediate scrutiny. So they look at the public interest justifications, the state interest for the law. When you're dealing with firearms laws, it's usually a very obvious state interest to protect people from being killed, injured, and there are others, but that's obviously the most obvious one. And then how does this law, is it systematically related to that interest? And in that, they'll look at, social science studies and what the legislature has looked at. And that is how lower courts have been assessing these laws. There is Justice Kavanaugh, when he was Judge Kavanaugh on the DC Circuit, said, well, no, this is not how you should be doing this. The Supreme Court, in his view, said you should just be looking at text, history, and tradition to assess the Second Amendment. So really a very originalist, looking at what was the understanding of the meaning of the right at the time it was enacted, what does tradition tell us? And courts have not done that, but it's, there are dissenting opinions. There certainly is, as I said, Justice Kavanaugh was in the lower courts. When the case that was just in front of the Supreme Court, both the plaintiffs, who are represented by former Solicitor General Paul Clement, and the Solicitor General's office itself, argued that this was the correct test, that you should be looking at text, history, and tradition. I don't agree with that. I think Darrell has put in a brief in the case saying that that is not the right approach, but that is, I think, sort of the next question that's going to determine a lot of how Second Amendment litigation and Second Amendment thinking goes forward.
And if I can just piggyback on that, I did, as a matter of full disclosure, wrote a brief with Joseph Locher and Eric Rubin on behalf of neither party, because it feels a little technical for non-lawyers about how the courts are supposed to analyze a Second Amendment case. But it really matters, especially for those of you who are interested in the policy arena and in the criminological or public health arenas, because it shapes the way the kind of information that you produce gets presented to the court. So in a two-part framework where we just ask a sort of threshold question, are we even dealing with a Second Amendment issue? Like robbing a bank with a gun is not a Second Amendment issue, and no court will say, well, we got to engage in the Second Amendment rights of bank robbers to use guns to rob banks. That's not happening. But once we actually find a question that is within what we might think of as an application of the Second Amendment, then we get to these sort of scrutiny questions. And that's where things like, well, how many people are killed with guns? How versus how many people protect themselves with guns, or what kind of other guns are available that can accomplish this kind of safety without these kinds of bad outcomes. That tends to come in this kind of tailoring practice that Bill was talking about, where the government is producing some kind of empirical record or evidence about why it has the regulation it does and what good it's doing. A total sort of abandonment of that portion of the test ends up relying a lot on analogies from history. And in some cases, you can't do that. So a strict text, history, and tradition test, which I don't think anybody would apply, would say only those regulations that existed at the time of the Second Amendment, which in 1791 are constitutional. So if you can't find a regulation that didn't exist in 1791, then your regulation's unconstitutional. And I don't think anybody agrees with that. What Kavanaugh says is what you have to do is work from analogy from 1791 or other traditional regulations to the modern era. And you can do that in some dimensions, but not in others. For example, in the 19th century, there were prohibitions on carrying guns into places of public amusement like fairs or markets or to places of public education. So, if you had a prohibition on carrying guns, for example, into a state university, that would have a fairly close analog to something in history. But there's lots of things that really force us into another type of analytical frame because the analogies don't work. So it's only been illegal to carry a firearm onto a jet airplane, a commercial airliner, since about the 1960s. The text history and tradition analysis with analogy doesn't quite work if we're trying to figure out, well, what kind of thing in 1791 looks like a jet plane? It's just, we don't have that kind of analogical mechanism for doing that kind of thing. And so either you have to argue about the level of abstraction that, oh, well, the regulations in 1791 were about crowded areas and, the interior of a jetliner is a crowded area. Or you have to sort of abandon this sort of analogical project altogether and then talk about, well, why would you want to ban guns in the jetliner? Well, because it's dangerous. How do we know it's dangerous? Well, then all the kind of social science and criminological data that we've just talked about comes back in.
Thanks. That's very both very helpful in understanding both the scope of the amendment and the methodological questions. Can I shift from constitutional analysis to statutory analysis? And in particular, I want to focus on one federal act in particular, which is the Protection of Unlawful Commerce in Arms Act. And Bill, maybe I could start with you. This is a statute that protects gun manufacturers and gun dealers from liability for the crimes that are committed with the products that they manufacture or sell. So could you explain a little bit more about the scope of protection of this act and maybe something also about its history and how Congress ended up passing this act?
Sure. So the Protection of Lawful Commerce in Arms Act, known as PLACA, which is much easier to say, is a federal statute passed in 2005. It gives, as Tommy said, special protection to the gun industry, a broad immunity from civil lawsuits that no other industry has. To think about the importance of this, when it was passed in 2005, the NRA said this is the most significant piece of pro-gun legislation in the last 20 years. So looking at other industries like automobiles, tobacco, pharmaceuticals, if someone is hurt by these products and the manufacturer acts negligently or recklessly, dangerously, they can be sued, right? And that's not, there are some exceptions to the statutes that we'll talk about a little bit, but that's not how it works for guns. The firearm industry has this PLACA statute where it can say, no, we have this special immunity, so you can't go forward like you would against other industries. So it closes the courthouse door to many people injured by guns. They don't have a day in court. They don't get compensation for their injuries. It eliminates financial incentives. So, other industries, automobiles I talked about, tobacco, pharmaceuticals, they have to take in the costs of litigation, and that causes them to make safer products. This exist in the gun industry, so there's no incentive from litigation to make safer guns, to engage in safer industry practices. So, there are safer guns. We know this. There are heavier triggers, chamber load indicators, which will tell you if a gun has something in a bullet in the chamber. These safety features, something that we could think could happen through litigation hasn't happened. You're controlling distribution channels, and in the opioid litigation now, there's claims that they've sort of released these drugs many more into areas which couldn't possibly legally need them for legal purposes, and there's negligence claims against that. You can't bring that sort of claim against the gun industry for releasing firearms into a place where there's just way too much for the legal market. So, as I said, there are exceptions to PLACA, but they're narrow ones. They're somewhat hard to prove. We did see recently in the Sandy Hook litigation, they brought a claim that at least survived the motion to dismiss stage, and the Supreme Court denied certiorari there, denied review, where they relied on an exception called the predicate exception, known as the predicate exception. Essentially, you have to show a violation of a federal or state statute applicable to the sale or manufacturing of firearms. The general debate there is a little more complicated, is what does applicable mean in that context? Is it a statute that's sort of exclusively or, directly about firearms, or can any, or no more general statutes, like in that case, it was the Connecticut Unfair Trade Practices Act, and the Connecticut Supreme Court there said, yes, that could be applied. So there are some, as I said, exceptions. There's other ones like negligent entrustment. You think about someone who gives their car to a drunk driver, that'd be negligent entrustment, something like that in firearms, but not a normal negligence action. You can't just bring that against the gun industry.
In talking about liability, an important actor in this world is, of course, is our insurers. And John, if I could bring you on this, do you see an opportunity then for liability insurers to play a role in regulating gun violence or preventing gun violence? Some commentators have focused very much on this idea of regulation by insurance being effective in other domains. Do you see it playing out here?
Yeah, it's certainly a question worth asking. I think if we want to think about the role of insurers in regulating gun violence, we're talking first about two very different kinds of insurance. One would be gun industry insurance, and the other would be insurance for individual gun owners or possessors. I think as far as gun industry insurance, what Bill just talked about, the PLACA statute, makes the insurance mechanism relatively impotent, because for insurers to have the incentive to step in and try to encourage manufacturers or distributors to make the product safer, make the distribution chain safer, requires a threat of liability. And if PLACA insulates the industry, for the most part, from the threat of liability, then there's not much for insurers, there's not much reason for insurers to be active in this area. And that's what we're seeing right now. The insurers who write coverage for gun manufacturers, distributors, it's very hands-off. It's a protection of capital in the face of potential catastrophic loss, but they're not in there from day to day doing inspections, the way that a property insurer might inspect this property to see if the sprinklers are working and see if the emergency escapes are locked or things like this. They're not doing this because the risk of liability is so low. I think where the more interesting issues are is on the individual side. And this has been an area ripe with proposals for legal reform. So in the wake of the Sandy Hook shooting, the federal government and I think 8 state governments, really 7 plus DC, considered proposals for an insurance requirement, laws that would require anyone who owns a gun to carry a specific gun insurance policy. They all failed. Hawaii, New Hampshire, New York, California, they've all considered similar bills, and they've all failed. This, of course, would be just like car insurance, right? Many states say if you want to drive a car, you have to have insurance. And this idea was a simple analogy. If you want to have a gun, you have to have insurance. I think there's 2 interesting questions to ask here. The first, which is really more in Daryl and Bill's wheelhouse, so I'm not going to talk about it, but I'll just put it on the table, is whether insurance mandates like that would withstand Second Amendment scrutiny. So I'm sure they would be challenged as violating Second Amendment rights. Would they withstand scrutiny? The other question, which I'll talk a little bit about, is, well, would they actually do any good, right? Would it help the world? Would it reduce gun violence? So why might anyone think that requiring people to get an insurance policy would reduce gun violence? I think the idea is that insurance can be a mechanism for forcing people to internalize the costs of owning dangerous products by using risk-based pricing. So this is, again, the same thing we do with cars, right? If you're an 18-year-old male and you want to own a car, you kind of got to pay a lot in insurance. And if you're a 45-year-old male, you pay less because you're less risky when you take that car on the road. And it would be a similar idea for gun owners. Insurers can also play a very important gatekeeping role. So if you're a risky enough driver, no one's going to insure you, and then you can't own a car. right? And so it's not the government telling you you can't own a car. The government's just saying you need insurance, and if no company is going to insure you, then you're out of luck. And so I think there's some hope on the part of the proponents of these bills that insurers could play a similar gatekeeping role with respect to gun ownership. And then the way the insurance mechanism works is that if an insurer writes you an insurance policy for your gun ownership, meaning that they're going to be on the hook if that gun kills somebody, hurts somebody, the insurer takes on a financial incentive to try to do things to make sure that that's not going to happen. So the insurer might take interest in, well, how are you storing that gun? And do you have a permit? And do you have training? And have you been educated about appropriate gun use? And this is all called loss prevention or risk mitigation, risk management. These are the kinds of things that insurers do. This is, again, analogous to an insurance company sending out an auditor to inspect the building to make sure that there aren't excessive risks around that increase the exposure to damage. And so people are hoping that if we could require gun owners to purchase this kind of insurance, that then the insurers would take an interest in regulating the safety of the gun use. The evidence to date is that the gun industry the insurance industry rather, is doing very, very little in this field. So when you look at life insurance policies, for example, insurance companies don't even ask about gun ownership. They ask about scuba diving, which according to Wikipedia is less dangerous than gun ownership, but they don't ask about gun ownership when deciding how to calibrate your premiums for your life insurance policy. Residential liability insurance, homeowners insurance, renters insurance, does cover some gun-related incidents. And I think this would be the area in which we could see action. Right now, there's one huge impediment to this being an effective tool, which is that these policies exclude intentional acts, meaning if you have a renter's policy, it covers you for liability generally, but if you take your gun and you intentionally harm someone with it, that's excluded. The insurer is not on the hook for that, and so the insurer has no incentive to try to take steps to make sure that you don't do that. There is some coverage that kicks in when negligence on the part of the homeowner allows a gun to get into the hands of somebody who then uses it to hurt people. Actually, the family members of the Columbine shooters had homeowners insurance that ended up compensating the families of the victims in wrongful death suits. But my understanding is that all things considered, this is relatively rare. So when you put together the fact that intentional acts are excluded, and that these cases where negligence on the part of the homeowner lets the gun into the hands of someone who uses it to harm people are relatively rare, you put those two facts together and you just have a situation where the insurers don't have any real incentive to care. If you have really valuable guns and they're writing you property insurance, they might ask about how you store them, and that might incidentally help prevent them from slipping into the hands of the wrong person, but from the liability perspective, they don't really care. So if there's one single target for legal reform that I think could potentially, if constitutional, make a difference here, it would be the bold act of eliminating the intentional act exclusion. Now, typically insurance policies have intentional act exclusions because we worry about moral hazard. We worry if we say, hey, Daryl, you have this gun insurance policy, and if you decide to take your gun and shoot somebody with it, don't worry, you're covered, right, if you're ever sued. Well, we don't want to do that because maybe it'll make Daryl more likely to shoot somebody. My intuition, backed by no evidence, my intuition is that that's not actually how the world would work. I don't think that Daryl would really be more likely to shoot somebody if he had liability insurance that would cover the costs of a wrongful death suit. And if you did get rid of the intentional act exclusion, it would really provide substantial motivation to insurers to try to step in and regulate gun owners and calculate premiums according to risk, make it costlier for riskier people to own guns. It would also, by the way, promote compensation of victims of gun violence, right? Right now, if you have no insurance and you go out and you kill somebody with a gun and they sue you for wrongful death, you probably, the average person doesn't have very deep pockets, doesn't have the ability to actually fully compensate the victim of that gun violence. If you had insurance, similarly to car insurance, now your insurer can actually provide compensation. So I think there's room to maneuver here. Right now, I don't think the insurance industry is playing a role, but this is why activists are paying attention to this in so many states right now.
I just want to jump, if I think the sort of gun rights advocates would say the car analogy doesn't work because you don't have a right to have a car, right?
You do have a right to travel.
You have a right to travel, but
Yeah.
not to travel in a car, right? So this is what you would run up against. Now, I think it's fair to say that there, in other areas which are just as contentious, there are licensing regimens for the production of a certain, for the technical capacity to accomplish a certain type of right. For example, I have not seen a successful litigation for an abortion provider who says, I don't have to have medical insurance, or I don't even have to have a medical license in order to perform this kind of service of which a person has a right. So, there are ways sort of thinking around this particular set of problems, but I think it would run into a legal problem, but also a political problem, because anything that looks like it would be an insurance mandate that is designed to actually stamp out the exercise of the right is going to be viewed with suspicion, especially by the lower courts that I think would be somewhat skeptical of insurance mandates. Doesn't mean they would necessarily fall. It just means that I imagine it would be a different kind of valence than other kind of insurance product. But the other interesting thing, and you know this already, which is for the private use of firearms, to the extent that lots of firearm rules are designed about having people have guns to protect others. In that sense, it's not that much different than, self-insuring municipalities or private insurance in markets for police, right? So if you have, I'm assuming the police are insured for what they do when they use their firearms, wrongfully and shoot somebody. There is an insurance market that disciplines that kind of use of firearms. I don't know why it wouldn't necessarily translate over when the premise is we've got people carrying guns for the protection of others, and when they wrongfully use it, therefore they need to have insurance in order to absorb the cost.
Can I ask about another aspect of the federal statutory regime? And I think it illustrates some of the complications and nuances in this area. And so one example is that there's a regulation that requires the ATF, the Bureau of Alcohol, Tobacco, and Firearms, to maintain a center, what's called the National Tracing Center. And that's a center that allows the processing of requests from federal, state, local, even foreign law enforcement agencies to trace guns, to trace crime guns. And a few years ago, there was a amendment that was tacked on to an appropriations bill known as the Tiahrt amendments, and that complicated this tracing process. So could you speak to sort of why those restrictions are problematic, and it gives us another example of the complications of the statutory regime at the federal level?
Sure. So those complications, as you said, the Tiahrt Amendment, I think they started in the mid-2000s and have been sort of enacted with appropriations bills since then. Essentially, they prevent public disclosure of this gun trace data. And gun trace data, that's, say you find a gun at a crime scene, it has a serial number, you go back to the manufacturer, and then you can trace the gun to essentially at least as far as you can go to the retailer who sold it, because they have to fill out ATF forms when you buy the gun. And so this can give a lot of information to researchers, legislatures about where are crime guns coming from. Before the T. Hart amendments, restricted this information, there's a lot of information out there about, there are certain gun stores in certain areas where a huge percentage of crime guns were coming from. So you could tailor legislation to attack that problem. You could also tailor lawsuits. So we talked about PLACA and its restrictions it put on lawsuits, but it's not just the immunities, and as I said, there are exceptions, and some lawsuits can still be brought, but you can't get this information. At least there's restrictions on getting this information, so you don't know, where you would bring sort of a big lawsuit to try to prevent, bad gun dealers from doing what they do, or you find you have a crime, you don't know who the gun dealer is that actually sold that gun. You can't find that out if you want to, get compensation for a victim. So, as I said, social scientists, researchers, legislatures trying to enact informed legislation can't even get this information from the ATF or from law enforcement. The public who would want to know this to lobby their legislatures to enact proper and appropriate laws. So that's essentially sort of the gist of the issue. And there is some, I just should say, at every town right now, we have a lawsuit which was successful in the Southern District to say that, is a FOIA request, the Freedom of Information Act, request to try to get some aggregate trace data about that we said was still available under, regardless of T. Hart. The district court there said, yes, actually, the way Congress did this, the T. Hart amendment doesn't apply to this FOIA request that we made. We'll see what happens, but there could be some, cracks in this, but it's still a very large barrier.
So we've gone from constitutional to the federal statutory regime. Now I want to turn attention to state legislation and state regulation. And it's a pretty varied topic. It's a lot of potential different approaches states are taking. So I'm going to give a kind of broad, open-ended question and invite you to sort of educate us and fill us in on what's going on at the state level. Sort of what have states done in reaction to what's going on at the state level, or what have states done in reaction to what's going on at the federal level, or what have they done generally, and are there challenges that are particular to states acting in this domain?
Right. So as I sort of mentioned before, the vast majority of gun regulation tends to be at the state and local level. There's a couple of federal statutes, but the assault weapons ban, for example, lapsed and was not renewed. So regulating, for example, high-capacity magazines tends to happen at the state or local level. And I think it's fair to say that with regard to state and local law in this area, the kind of legislation that's produced reflects the kind of partisan divisions over guns themselves. So typically what happens in Republican-dominated legislatures is they enact very gun-friendly kinds of regulations, including things like stand your ground that has to do with being able to use a gun to self-defense, passing legislation that prohibits local law enforcement officers from stopping somebody with a gun and asking them, why do you have this gun? Those kinds of things. So one direction is states that enact very gun rights protective kind of laws, way more than what the Second Amendment establishes as a floor. In the other direction, as is evidenced by Virginia and California and what we might think of as sort of blue states, you usually get some sort of regulation in the opposite direction. So prohibitions on things like high-capacity magazines, may issue regimes where the sheriff will only issue you a license if you show a demonstrable need for the gun, as opposed to just not being a criminal or a felon or whatever. And then to sort of decompose this even more, you end up getting a set of conflicts between states and municipalities. So many states, for example, will use their power to preempt local governments in the area of gun regulation. So Florida, for example, has a series of extremely punitive preemption provisions that will punish local governments that try to pass gun restrictions of any kind. And the obverse has created this sort of phenomena of the so-called Second Amendment sanctuary, where you have a state like Virginia, which is dominated by Democrats, passing gun legislation, and then local communities, usually rural, saying, we are not going to help the state enforce these kinds of gun safety regulations, and we are going to oppose them. And so there's a mosaic, as it were, of gun rights enabling and gun safety enabling legislation that tends to be denominated at both the state and the local level by the disagreements about sort of party alliances.
Bill?
Yeah, I would just add to that. I mean, so what states, as you mentioned, the federal government is very limited in its role in gun regulation. States have, to a large degree, as Daryl said, done different things, but where they've come in is to fill in some of these gaps in federal regulation. So background checks on all gun sales is something that we saw proposed in the House this year, didn't go anywhere past the House, but a lot of states have filled in that gap. So you now have 21 states and the District of Columbia now have their own state laws that prohibit, that require background checks on all gun sales. And this is, it's important. Look at a state like Virginia, which may be on the cusp of doing that and adding to that total. Virginia is a sort of a hotbed, a source, a major Northeast source of gun trafficking. So, if you have, without background checks, it becomes an easier thing to do. With stronger laws in Virginia that might make it, along with just background checks, they also enacted a law that you can only buy one firearm a month, one handgun a month, which again is help restrict gun trafficking, be a source of gun trafficking. So that's something that states can do. The states have also innovated. So you've seen innovative policies in the states that we're not seeing even thought of at the federal level at first, like was called the extreme risk laws or red flag laws. So when a court finds that someone is a risk to themselves or others, they can temporarily take away their firearms and suspend their ability to purchase firearms. This is, in blue states, but also in some, what we call maybe at least purple states have latched onto this as a sort of a reasonable gun regulation. So that's the sort of thing that states are doing, both filling in gaps and innovating. I think that's sort of an important part of what we can learn from state regulation.
John, can I turn to you and ask about one other important aspect of state regulation, and that's just the criminal law itself. And what role does the criminal law have in regulating gun violence? And sort of what are the potential advantages or disadvantages to looking to criminal law to regulate gun violence as opposed to looking at the forms of civil regulation that we've just heard about?
Yeah, well, I'm glad you asked, because I think this is a really important part of the picture that doesn't get talked about quite as much as some of the other issues we've been discussing. Whenever we hear about a surge or just a generally high level of gun violence, we tend to see a push for more prosecutions of people who have firearms. This tends to be an area of consensus between what you might sort of crassly call, gun-skeptical liberals and law and order conservatives, right? They kind of agree, well, let's go after these, bad guys with guns and let's put them away. So, for example, in 2017, Attorney General Sessions issued a Department of Justice memo directing U.S. attorneys to prosecute more felon in possession cases. Felon in possession is a federal statute that makes it a crime to possess a gun. if you have been convicted of a felony. There are some exceptions, which I'll talk about a little bit later, but for the most part, the vast majority of felonies disqualify you from carrying a gun. So Sessions says we need to be prosecuting more of these cases. Our own state here in Illinois, since 2000, the Illinois legislature has raised the penalties, criminal penalties for unlawful gun possession 6 times. And even more locally, our Mayor Lightfoot, she has used a lot of sort of criminal law rhetoric in talking about the fight against gun violence, and very much has announced an intention to use policing and criminal courts and incarceration as a way to keep gun offenders off the streets. So there's some provocative work by a friend of mine and a law professor at University of Colorado named Ben Levin. He has an interesting article where he compares the war on guns, as he calls it, to the war on drugs, and asks whether some of the criticisms that we have mounted against the war on drugs also should apply to this war on guns mentality as well. And in particular, he focuses on problems of police and prosecutorial discretion and power, worries about the social and economic costs of incarceration, and then race and class-based critiques. So I thought I'd take a minute just to think a little bit, or at least do some facts to help us think about whether there's anything to this analogy between the war on drugs and the war on guns. So, as a fact of the matter, these felon in possession statutes that I mentioned, these are the primary tool for using the criminal law in the fight against gun violence. 94% of weapons prosecutions in the federal system are under the felon in possession statute. And these crimes carry very significant sentences. So about 95% of federal weapons defendants who are convicted serve prison time. Average sentence is 53 months. There are a lot of at least well-known in criminal justice circles, sentencing enhancements related to guns. So if you possess a gun while you commit a drug trafficking offense, that's a mandatory 5-year sentence, 60 months. And if you've had 3 drug trafficking convictions on your record, and then you're found with a gun, that's a 15-year minimum sentence. And about 10%, 11% of federal weapons defendants who are prosecuted under statutes that carry these kind of mandatory minimum terms. And this makes a really non-negligible contribution to the prison population. About 20% of federal prisoners are serving time for weapons offenses. Now, the federal prison population is smaller than the state prison population. In the state side, it's only about 4%, but that's still about 60,000 people in state prisons for gun offenses. And again, in the federal side, about 20%. There are great racial disparities in the prosecution of these cases. So in the federal system, about 53% of individuals who are prosecuted for weapons offenses are Black. Interestingly, only 1% are college graduates. In New York, there's data from stop and frisk and arrest data. 70% of individuals arrested for gun offenses in New York are Black. This seems to be a disparity in comparison to baseline rates of gun ownership. Unfortunately, we don't have good data on rates of illegal gun ownership. We know that actually white Americans possess guns at a higher rate than Black Americans do. And there are, of course, many more white Americans, so that suggests that if 70% of your arrestees are Black, that there might be some discrimination or some disparity going on, but we can't tie a bow on that argument because we don't know the underlying rates of illegal gun ownership. But it's interesting too, there's an interesting link between the war on drugs and the war on guns, which is that there is a great racial disparity in underlying felony records, and that leads to, I think, these disparities in felon in possession cases. So, only about 8% of the general population in America has a felony record. But if you look at the black male population, that figure is 33%. And so that means that way more black male Americans are disqualified from owning guns than the number in the general population. And so it leads to this sort of cycle where if, because of the war on drugs, there's this huge number of black men who have felony records, then you would expect that that would lead to disparities in arrests and prosecutions and sentencing for felon in possession records. There's also a carve-out in the felon in possession statute for white-collar crime, but not for drug crimes, even when those drug crimes are nonviolent. So the district court in the District of Columbia recently decided a case where there was a CEO who had served 18 months for fraud and was charged with felon in possession and successfully argued that he fell into this defense. And he said, I'm not the right kind of felon, right? You want the drug felons and the violent felons, but not me. I can still own a gun. Now, the last question that's worth asking is whether any of this is doing any good, right? You know, if having 20% of federal prisoners be there on weapons charges is actually keeping us safer, then we could have a real conversation about whether it's worth it. There's very little evidence that it is. There's not a lot of evidence that it is not. There's just an absence of evidence. The correlation between the existence of or enforcement of felon in possession statutes and rates of gun violence is very, very unclear. I was not able to find any rigorous studies on this point. I found one study from 2016 in the Criminal Justice Policy Review that found a weak correlation between bans on criminals purchasing guns and violence, but it was weaker than the correlation between bans on alcoholics purchasing guns and gun violence. So I think there's a lot of room here for research on whether this use of the criminal apparatus and all these arrests and prosecutions and all these years people are serving in prison is actually keeping our community safer, because I don't think that we know that it is, and it's having obvious costs, and those costs are being borne disproportionately by communities of color.
So I think we have time for questions, and so I encourage anyone who has questions to please go to the back. We've got 2 microphones in the back, so everyone can hear your question. Let me ask one more question before we open up to the floor, and that is specifically on, I think, sort of an intersection between the 2 items we've just talked about last, which is the criminal law and then civil regulation at the state and local level. And that is, and maybe Bill, I could ask you, domestic violence surrender laws. How widespread are those? Are those being subject to challenge? What's the role of those?
They're becoming more widespread, so they are being subject to challenge. I mean, it's a difficulty because there are a lot of states where there'll be a law saying you have to, give up your gun or you're no longer allowed to possess a firearm, but there's no means by which they take that firearm away. So there are, especially with some of these extreme risk laws now, there are provisions for surrender or, you have to turn the gun over, and some localities in California, they have a system whereby they will go to someone's home, and this is the sort of danger that gun rights people go to someone's going to kind of help and take your guns, but this is a very dangerous situation. We know that domestic violence and guns are a terrible mix, lead to more violence, lead to death. So I think that's an important thing that making sure that whether it's the judge requiring it in when he's ordering that domestic violence restraining order, also requiring that they turn over that gun. That's happening more in states where it's not an option for a judge to make that part of the restraining order. That it's a requirement that they say you turn over your gun, and it's a requirement that they turn over that gun, and there's a requirement that they affirm that they have no guns anymore. So I think that's an important step that's happening in the states, but it is it's an ongoing process.
Well, thank you. So let's sir, there's a number of questions. Let's open it up to questions, and let's start here. Yes.
Hello. Is this this working? Okay. I had a question, I think primarily for John because of what you were speaking about in the kind of criminal law area, and then also your very interesting framework when it came to insurance. But I just wanted to ask about the fact that a majority of firearm deaths are from suicide and how that fits into the insurance framework and then also like gun safety law framework and things like that.
Yeah, I mean, it's an obvious question for insurers, I think. When I mentioned that, for example, life insurance might have exclusions for suicide generally unrelated to gun violence. And so maybe that's a reason that they don't need to care about gun ownership. I said that when you take out a life insurance policy, they don't ask questions about your gun ownership. They ask questions about your scuba diving, but they don't ask questions about your gun ownership. But there, you might also imagine situations where the owner of the gun is not the one who uses the gun to commit suicide and so on. And there's a little bit of a mystery. There's a little bit of a puzzle. Tom Baker, who writes a lot about insurance, he's a law professor at University of Pennsylvania, has sort of wondered in writing about why insurers aren't a little more attuned to this, and some of the things I mentioned about the way the guns are secured and stored, right, which could prevent a suicidal member of the family from taking the gun. The only times they ask questions about this are when it seems to implicate property risks, right, when the guns are valuable, and so we want to make sure that they're secured. So I don't know. It's possible, sometimes we caricature insurers as being the most rational actors in the universe, and if they're not doing it, it must be because, it doesn't make sense to do it. But as I've gotten to know more and more insurers, I have, that caricature has become erased in my mind, and I think that, there's a lot of art to it too. And, for example, I have written a lot about police insurance. I've asked insurers, do you take into account whether a police department is unionized when you set premiums? Because, I happen to have a paper suggesting that, collective bargaining increases police misconduct, and they say, no, we don't ask about that. There may be political reasons they're not asking about it, right? They don't want to imply to the police departments that they're anti-union, and maybe here we don't want to imply that we're sort of anti-gun by asking you all these questions about your guns, because maybe that has a bad political valence, and maybe we'd be branded as the anti-gun insurer, and the NRA would tell no one to buy, tell everyone don't buy State Farm insurance, they hate gun owners. I don't know. So I think there's a lot of room for thinking here, and there's a lot we don't know about why they're not being more proactive on issues like this.
Great.
Thank you.
Yes.
Oh, hi, I'm Dr. Damon Arnold, but I actually working for an insurance industry. I'd love to talk to you, but Blue Cross Blue Shield of Illinois. But I also I was also a veteran, so I actually was in the Army National Guard 26 years, and as part of my studies at the Center for Homeland Defense and Security and Naval Postgraduate School, what I did do is completed a thesis, and the first opening comment in the thesis was, first of all, we had to stop the polarization around the issue. So taking a step back, it's really about gun safety and security rather than control. And I'm not sure if the legal profession needs to take a step back in its terminology that it uses when it's making laws with respect to the word of ban and those kinds of terminologies that may polarize people when you're trying to push legislation through, centered on legal constructs. And the other one, in a really brief comment on this, is, with RFID technology, I always look at the Second Amendment and they say well-regulated militia. And I'm not sure if there is any role for technological tracing of guns or tracking. I know there was a Fast and Furious issue in the background, but is there a way for technology to play a role?
So thanks for that. And, actually, your point's well taken. I think Rand did a study that said, in terms of goals between sort of gun owners and regulators, there's not there's not as much distance as one would think between what they think the ultimate goal is. It's just that they have like radically different ideas about how to accomplish it. The gun rights camp really believes that having more guns in more hands leads to overall safety. And the gun regulation or gun violence prevention camp doesn't think that that's true. And you know, everybody has their own set of econometric data that's subject to sort of dispute on either side of this potential question. I think you're right that that understanding the entire structure of the Second Amendment and guns as about safety certainly helps calm down the more radical voices in the debate. But there's an incredible amount of distrust, and I'm not going to create a false symmetry. There's an incredible amount of distrust, especially among gun owners, that the next Supreme Court case, the next regulation is the step to universal confiscation of private firearms. And not even Heller, which is a case that says, no, you can't do that because the Second Amendment protects a right to have a firearm in the home for self-defense. Not even that particular opinion assuages the person that is certain that, you know, the knock on the door is the person coming in to take their guns. And so in sort of trying to figure out what the political compromise is, you know, it is trying to create, I think, as you identified, a language of saying, nobody is here for universal confiscation. This is not what this is about. This is about trying to have policies in place that reduce or eliminate what everybody would agree is an unacceptable set of circumstances. High rates of suicide with firearms. Nobody, you know, should have to duck and cover in their schools because they're afraid that somebody's going to shoot up the school. You know, mass shootings, which are a small portion of the entire gun violence pie. If you look at a pie chart, it's very minuscule but highly salient. And I think most everybody agrees that we don't want that, and let's try to find those points of agreement where we can say, hey, these kinds of interventions, including technology, might actually reduce the overall level of gun violence.
Okay. Yes.
So this is primarily a question for Professor Miller, Mr. Taylor. I want to ask about the use of the Second Amendment or state law as sort of a sword rather than a shield. So you have a private landowner like the University of Chicago or a public landowner like the University of Illinois that wants to exclude people from carrying guns on its property. Have there been attempts by litigants to use the Second Amendment to sort of force their way on despite whatever gun prohibition that the property owner wanted to impose, or have there been state laws that would sort of ban property or prevent property owners from imposing those kinds of limitations on the guns that can be carried on their property?
Yes and yes. Yes, there has been the deployment of Second Amendment arguments, for example, in people that want to take their guns into Starbucks. But, you know, for the lawyers in the room, we know that that doesn't make any sense because Starbucks is not a state actor. It has no obligation to respect constitutional restrictions on what it wants to do with its own property. But it has an incredible political power, you know, when you say, hey, you know, this big company is taking away my Second Amendment rights, which basically is just a loose way of saying I don't like what the big company is doing. Those obviously are not successful as legal matters. What has been more successful is what are known as parking lot laws or take your gun to work laws, or sometimes known as forced entry laws. And these are laws where states will say if you are a property owner or an employer, you have to permit employees and contractors to carry their concealed weapons onto your property. And in some cases prohibits the employer from even asking whether the employee has a gun on the property. Those have been subject to various kinds of challenges based on property rights. I think with some marginal success. The interesting thing, as you well know, and I've written on this, is to the extent to which a private company can claim that its own rights-bearing interests are impacted by being forced to allow somebody else with guns onto its property, right? So if Chicago says, hey, we are a private organization and we have a security detail and only those people have guns at the University of Chicago, and somebody like the state of Illinois says, no, you have to allow other gun owners onto the property of the University of Chicago, one argument would be, well, that's impacting our collective University of Chicago Second Amendment interests in self-defense.
And
So-
just to add to that, so in the parking lot laws, we currently have a case at Everytown where we're representing some domestic violence shelters and a coalition of domestic violence shelters that have their own ownership of private parking lots and want to prevent people, as we talked about, dangers of people who are in domestic violence shelters are trying to stay away from people who might have guns, trying to prevent, guns in their parking lots, and they're challenging that state law that would, not let them do that. So it's a situation that's happening in a lot of states. The West Virginia law was actually fairly recent, so it's continuing to occur. And as Gerald said, there have been challenges on property rights and other theories.
Now, there are more questions as a sign of a great panel, but we have reached the end of our time. So I want to first encourage everyone as we transition to the next panel, don't leave the room, get up, stretch, but don't leave the room. We're going to have a break later. Those questions that you didn't get a chance to ask, of course, we'll have an opportunity to ask at the break and at lunchtime. But we're going to transition now to the panel on politics and policy issues. But first, please join me in thanking Darrell Miller, John Rappaport, and Bill Taylor.